Before anything, I will be introducing Professor Brandt to everyone. So bear with me, guys. Yeah.
Okay.
Yeah. Good evening to everyone that is, those are in Nepal, and good morning to Professor Brandt. Welcome to today's online lecture, where we are honored to have Professor Ronald Brand as our distinguished speaker. Professor Brand is a prominent figure in international legal education, renowned for his extensive contribution to the field. He is the founding director of Pitt's Law Center for International Legal Education, also known as CILE, and has been instrumental in establishing its Masters of Laws program for foreign law graduates and Doctor of Juridical Studies SJD program. Professor Brand's academic influence extends globally, with teaching experiences in numerous countries and a body of scholarship that is frequently cited worldwide. His commitment to legal education is evident through the development of innovative programs and courses providing Pitt Law students with unparalleled opportunities to engage in international law, both in Pittsburgh and across the world. Professor Brand's excellence in teaching has been recognized with several awards, including the Chancellor's Distinguished Teaching Award and Law School's Excellence in Teaching Award. His public service contributions have also been acknowledged with the Chancellor's Distinguished Public Service Award. Representing the United States in various capacities at the Hague Conference on Private International Law, Professor Brand has played a pivotal role in the development of significant conventions, including the 2005 Convention on the Choice of Court Agreements and 2019 Convention on the Recognition and Enforcement of Judgments in Civil or Commercial Matters. His ongoing work with the U.S. Department of Commerce has contributed to the enhancement of law school curricula and the training of legal professionals in international commercial law and arbitration across Middle East, South Asia, and North Africa. And during one of these programs, I met Professor Brand in Abu Dhabi for the MENA Pre-Moot, where for the first time, where he guided us on various topics related to arbitration. Believe me, he is one of the best in the field and has the answers for almost everything. I often used his expertise to test out my arguments in the race last year. And I'm pretty sure that all of you attending the session are lucky to have him teaching you today. Without further ado, I'd like to pass on the floor to Mr. Brand, Professor Brand, sorry. Thank you, Professor.
Thank you, Prajwal, and thank you for everyone who helped put this together. I appreciate the opportunity to meet with you. Good afternoon. It's morning here in Pittsburgh, but it's nice to be with you. And as Prajwal said, I've met, and I think I've met perhaps some of the others who are on the screen here with names too in the CLDP programs in the Middle East. I want to provide, I hope, some helpful information. Please feel free to jump in with questions, because questions help. What's important is not what's in my mind and what I think you should know. What's important is what's in your mind and where you are. And if there's a question something that's blocking understanding here, jump in, turn on your camera, and then just jump in and ask the question. That's easier than putting it in a chat, at least for me. So I'm going to share my screen here. And so you'll see less of me and more of the PowerPoint slides. And so what is it we're going to do here? We're going to talk about jurisdictional challenges. And the goal here is to develop a framework for analysis of issues of arbitral jurisdiction. And for those of you thinking about the vis moot, this is a way of preparing for a likely vis moot issue. As you all know, the Vis-Moot problem usually has two parts, well, always has two parts. One is arbitration law, the procedural part, and the other is the substance, the CISG, the United Nations Convention on Contracts for the International Sale of Goods. And quite often, the question that arises in the arbitration side of the matter is a question of the jurisdiction of the arbitral tribunal. And that always makes a good question. So what I'm hoping we can do here is develop a way that if that's the question in the problem, or if in any time you are in an arbitration, because that's what we really want to do is prepare you for this work after law school. If you're in an arbitration, that you're able to determine the issues and how to break it down. Because it's any time on any legal issue, you need to start with a way to break it down to the basic questions. And for the questions of arbitral jurisdiction, that means dealing with what we call private international law. And when we deal with questions of arbitration jurisdiction, we're dealing with questions of choice of forum, because you don't have arbitration without consent, and that consent is provided in an arbitration agreement, quite often a clause included in a larger sales contract or international commercial law contract. The term private international law is a term that we use. Sometimes it's referred to as conflict of laws, but we have three very fundamental questions that are addressed when we talk about private international law. The first one is jurisdiction. Now, in arbitration, that's the question of whether or not there is consent, because without consent, you cannot have the arbitration. And that's the only basis for jurisdiction in arbitration. That's different from courts. The second question is, what law applies once we have the question of jurisdiction satisfied and can move forward? But it's not just the question of applicable law on the substance. What we're going to focus on here today is the applicable law on the jurisdiction question itself. The third element of the private international law trilogy is the recognition and enforcement of decisions. In arbitration, that's recognition and enforcement of the arbitral award. That's governed in over 107 countries by the New York Convention, the United Nations Convention on the recognition and enforcement of foreign arbitral awards. So these three pillars of private international law are matters that help you break down questions for purposes of analysis in the law. Now, the first question in addressing any legal issue and dispute resolution is, what is that second pillar of private international law? And it is, what law governs? You can't answer the question when you're providing legal analysis until you know what the law is you are applying. And quite often, and particularly in international transactions, there are multiple sources of law that might be the governing law. But everything else depends on the answer to this single question. And that's true when we deal with, for example, the Vis-Moot problem and questions of jurisdictional challenge when one party, usually the respondent, has questioned the jurisdiction of the arbitral tribunal. Now, I want to start with some fundamental issues on private international and choice of forum, and this applies to choice of forum more broadly, and that would include both arbitration and choice of court. Rules of private international law are most often considered in the dispute resolution context. That's the litigation context or the arbitration context. And quite often in law schools, that's the way they're taught. And you think of them after the problem arises. But when we, and particularly in arbitration, that's not the first place these rules arise. Rules of private international law are fundamental to the practice of transactional law, to the persons who draft the contract, the transaction planning lawyer. So the transaction planning lawyer must understand these rules. They're not just rules for dispute resolution. But the dispute resolution lawyer must then be able to look back and understand the choices made or not made in the process of drafting an arbitration clause in an international commercial contract. And that's going to be ultimately our focus here. But I want to build the foundation for understanding that so that we have the foundation for breaking down the problem and putting the issues in the easier boxes so that we can have more simple questions rather than seeing it as just a complex set of questions. So let's start at the transaction planning stage. The transaction planning process places the lawyer in the middle of an existing business relationship. When it's an international commercial contract relationship, the client comes to the lawyer, transaction is probably already halfway negotiated at least, and the lawyer is brought in. That has consequences. And those consequences are, I think, best understood by looking at one word, and that's the word risk. The lawyer's role in transaction planning focuses on that question of risk. The lawyer must identify and deal with the risks that might arise in the transaction planning process. Now, as I mentioned, the lawyer usually comes in after the business people already have been talking to each other about the contract. And for the business people, this means relationships. And the better the relationship, the lower the risk. You know that in your own dealings in life, that the better you know the person you're dealing with, the more easily you will be able to work out any problems that arise in that relationship. So the relationship lesson when addressing risk is begin by developing good relationships. And that's the rule for the business person. So let's turn to the lawyer. The lawyer has to look at the existing business relationship or the planned business relationship and work with a risk. The first step is to identify the risks. You as lawyers will need to be able to identify what the risks are so that you can plan the process. Once you've identified the risk, the lawyer's role is to eliminate the risk if possible, and that can be done at times. And there are different ways to eliminate a risk, and we'll talk about that. If the risk cannot be eliminated, then the lawyer's role is to reduce the risk. And if it can be not eliminated completely or totally reduced, then the lawyer's role is to reallocate the risk. If the risk falls on your client, you want to, in the contract, put in the language that makes the risk fall on the other client. That's the job of the transaction planning lawyer. So number one is to identify the risk, but then in addressing the risk, eliminate it if possible. If you can't eliminate it, reduce it, and then work to reallocate it. So what are the tools the lawyer has to do this? What do you use to do this? Well, there are three types of tools. The first is institutional protection, and this is what you're learning in law school. The legal institutions exist, and you can use them. In the VIS problem, the kind of basic type of institutional protection comes in the New York Convention and usually the model arbitration law on the arbitration side, and comes in the CISG on the substantive law side. Those provide institutional protection because they have sets of rules that allocate the risk and protect the parties. And if they're well-drafted sets of default rules, they will also reduce risk because you'll have a better idea of what the outcome is if a certain problem arises. The second source of protection the lawyer has in addressing risk is purchase protection. There are times when you can, at a price, reduce the risk in a kind of international, the classic international sales transaction. The best example of that is that you can purchase a letter of credit, and that reduces the seller's risk of non-payment because you can go to the bank to get paid, not just the other party to get paid. And the third tool for addressing risk is the contract, negotiated protection. Once you know what the law is, if you don't put something in the contract and you know where you can purchase protection and have purchase protection, then the rest of it is a matter of drafting the contract, of negotiating the protection. So at the transaction stage, the lawyer must reverse engineer the choice of forum. The lawyer must identify how and when choice of forum issues will arise and how they might be challenged when they do arise. And then plan for the risk of an inconvenient forum and for potential challenges to jurisdiction. And then to draft to provide for a convenient forum that will be able to move forward with any dispute. Now, in the context of the vis moot, all of this often arises when we see that the language of the choice of forum clause, the language of the arbitration agreement, isn't always clear or hasn't dealt with all of the issues that might arise, and one of those issues has arisen. This is why the job of the transaction planning lawyer is really much more difficult than the job of the litigation or arbitration lawyer, because when you have the dispute, you already know what the problem is. You can identify the applicable law, and you can then make the arguments for the resolution that best fits your client's position. When you're drafting the contract, you have to be able to predict all of the problems that can arise, find the law that would apply if you don't do anything about it, and then, to the extent that you want to change that, put it in the contract in language that will mean the same thing to everybody who reads it. That's not an easy process. So at the transaction planning stage, you have to start by understanding the institutional protection, understanding the default rules in order to exercise party autonomy, in order to draft the contract to change any of the default rules you want to change. But in every legal system, there are limitations on what you can do through freedom of contract. So you have to understand the limitations on party autonomy. You then need to draft an effective choice of forum clause. And in our context, that is the arbitration agreement. Peter Nye was a famous private international law scholar from Australia, and when in his book Autonomy in International Contracts in 1999, he says freedom of contract is an essential part of the market economy. No state can hope effectively to control international contracts. Now, every state does try to control international contracts, and so you have to know just how the law has gone about that. At the transaction planning stage, there are choices to be made. And if you're drafting a choice of forum clause in order to help provide predictability if disputes should arise, you have a choice between arbitration and litigation. Arbitration is governed by the New York Convention, over 170 parties. Litigation by the Hague Choice of Court Convention, not as many parties, but that's going to change, particularly in the lifetime in which you will practice law. And But what you need to understand is the rules are very similar. And so when the transaction planning lawyer is drafting the contract, drafting the choice of forum agreement, there's a choice to be made. And if both conventions would apply, then that choice must be made with an understanding of what the default rules are, what the institutional protection is if you choose arbitration, what the institutional protection is if you choose litigation. As you know, Article 2 of the New York Convention says that agreements to arbitrate will be honored. An estate court shall refer the parties to arbitration if there is an arbitration agreement. The same basic rule exists in the Hague Convention. If there is an exclusive choice of court agreement, the parties will be referred to that court. That court will have jurisdiction. It will be exclusive, and other courts should not take jurisdiction. Now, there are limitations on this, and those limitations come from the limitations on party autonomy. If, for some reason, the agreement to arbitrate or the agreement to choose a court is prohibited by law, and that makes the choice void, then that agreement will, of course, be ineffective. The New York Convention and the Hague Convention then moved from the jurisdiction rules to the recognition and enforcement rules. Remember, those two parts of the three-part trilogy of private international law. They're found in each of these conventions. And in the New York Convention, you move from Article 2, the jurisdiction rule, to Article 3, which is the recognition rule. And it says that arbitral awards will be recognized and enforced. And the same way in Article 8 of the Hague Convention, judgments of the chosen court shall be recognized and enforced. In each case with a set of basic grounds for non-recognition that protect either interests of the state or interests of the parties in terms of fairness and what we in the United States at least call basic due process. And we can come back to those, but I want to look at the kind of bigger picture so that we've got the framework for analysis here. The result of the status of these two conventions creates a very strong incentive for using arbitration rather than litigation. With more than 170 countries, 172 now being parties to the New York Convention, that means if you get the arbitral award, you can take it. It's harder for the other party to hide their assets because you can get at those assets in 172 different countries. That's not true of the Hague Convention, which right now has 34 parties. 28 of those are the 27 EU member states and the EU itself. So not very widely adopted at this point. This is why in international commercial contracts, the transaction planning lawyer has a huge incentive to put an arbitration clause in instead of a choice of court clause. It does give arbitration many advantages, but if you're the transaction planning lawyer, you have to realize that arbitration is not always the best choice, and you need to think about and understand what the differences are between arbitration and litigation. And arbitration may be good for the very large transactions, but not always as good for some smaller ones because of the cost of arbitration. The transaction planning lawyer, however, must make a well-informed decision. When the transaction planning lawyer does that, there are 5 basic questions. If we reverse engineer the choice of forum agreement, if we think about what happens when a dispute arises, and then how do we try to prevent that, we can break it down, and this breakdown becomes very important when you're addressing the problem at the dispute resolution stage. And I hope this provides a framework for reading the VIS problem and trying to address the issues. Because if you think about it, there are really only 5 basic categories of problems that can be used to challenge the jurisdiction of an arbitral tribunal or the jurisdiction of a court. The first one is there is no agreement. The parties have not consented to arbitration. And we'll come back to that. The second one is formal validity. Maybe they consented, but they didn't do it in the form that is required. In the New York Convention, it says an agreement in writing signed by the parties or other exchange of writings that demonstrates the formal validity of the agreement. The third question is substantive validity, and that's that language in both the New York Convention and the Hague Convention that says that an agreement will be recognized and enforced unless it is void. And this is where, and we'll take a closer look at this, the source of law really matters. And it's not always so easy to find the source. You have to look widely on this one. This includes questions of capacity and arbitrability. And a lot of times you'll hear it discussed in that language. The fourth basic challenge is scope. Yes, the parties agreed to arbitration. The agreement is formally valid. It's substantively valid, but they didn't agree to arbitrate these questions. These questions are outside of the scope of the agreement to arbitrate. And finally, a question that more likely will arise in choice of court than in arbitration, and that's exclusivity. It's pretty much assumed that if you choose arbitration, that's exclusive to everything else. And the New York Convention makes it that by enforcing that agreement. The Hague Convention applies only to exclusive choice of court agreements, and there are a lot of contracts, particularly in the financial industry, where parties can go to several different courts, but they have to go to one of those, but that's not an exclusive choice of court agreement. Now we can break down these 5 categories into groupings. The first one is the existence of the agreement. Is there an agreement? The second question then is, well, is the agreement effective? Does it comply with the law? Is it formally valid? Is it substantively valid? And the third is the extent of the agreement. Does it reach the questions that are to be considered in this arbitration? Okay. And then that's a matter of exclusivity itself. Now let's go back and let's try to put some of this together at the dispute resolution stage. That first question, because in order to determine if a contract exists, we must know what law applies to make that determination. Okay? What law do we apply? Well, contract formation is a question of basic substantive contract law. It's not a question of arbitration law. The New York Convention does not have rules for contract formation. The UNCITRAL model law does not have rules of contract formation. That's a question of contract law. And of course, in the this problem, that often means you need to refer to the CISG, the UN Convention on Contracts for the International Sale of Goods. But it's a fundamental question. Did the parties agree? Is there consent? Okay. Now, validity is usually not governed by contract law. And in fact, Article 4 of the CISG says that very specifically, the CISG does not govern questions of validity of the contract. So this is a matter for the law governing choice of forum agreements, for arbitration agreements. And the question is, when does a state restrict choice of forum regardless of party consent? So even if there's an agreement When does the state say that agreement is not valid? This is a question of state interest, and it results in limitations on party autonomy. So for the transactions lawyer, you have to know this because it tells you what you can't do. For the dispute resolution lawyer, it tells you whether or not what the parties have tried to do is in fact effective. And then scope and exclusivity are questions of the extent of an agreement. And these take us back to contract law. These are questions of intent, questions of contract interpretation. At the transaction stage, they are matters for careful drafting. At the litigation arbitration stage, they are matters that you can look to if you are the party that doesn't want to be in arbitration to challenge the jurisdiction of the arbitral tribunal by saying the agreement doesn't include in the scope of the arbitration clause addressing these questions. And again, matters of contract interpretation. So you see here how when you, if your question is, how do I read the vis problem? You break it down. And if there's a challenge to jurisdiction of the arbitral tribunal, you ask, well, what is that challenge? Is it a challenge to the existence of the agreement, the validity of the agreement, or the scope and exclusivity? The extent of the agreement. Excuse me. So let's dig in a little deeper on the arbitration question and see how and textually where you go to answer these questions. And we begin again with Article 2 of the New York Convention. Sorry about that. But it starts out by saying each contracting state shall recognize an agreement. Now, I've seen a lot of people argue a New York, a vis problem by saying there is no valid arbitration agreement. That happened in last year's problem. But they don't understand, they make it more complex than it needs to be because they don't understand that that's two questions. The first question is there an agreement? And then you ask, and only then can you ask, is it valid? Because you don't need to if there is no agreement. And Article 2, Paragraph 1 of the New York Convention recognizes this. And you don't get into Article 2 unless you have an agreement. Okay, so that's the consent question of existence of a contract to arbitrate. But the same sentence in the New York Convention also brings in the question of substantive validity. Even if there is an agreement, it must be concerning a subject matter capable of settlement by arbitration. That's often referred to as arbitrability. But there are rules in many states that say certain types of transactions, consumer transactions, distributorship, some license agreements, cannot be taken to arbitration. That's a question of substantive validity, and you look to the law outside of contract law. Questions of extent, consent are matters of contract formation and governed by contract law. Now, Article 2.2 of the New York Convention brings in a very specific formal validity requirement, and this often comes up in the vis moot problem. The term, if you go back to question 1, under which it requires an agreement in writing. And paragraph 2 then tells us that that term, agreement in writing, can be or includes a clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. It must be in a written form that you can use in evidence. Okay? That's the formal validity requirement. And the source of the law for that is the New York Convention. And it may be developed further in the lex arbitri, the applicable arbitration law, which in the Wismut is always the UNCITRAL model law. Paragraph 3 then of Article 2 comes back to questions of validity. The court shall refer the parties to arbitration unless it finds that the arbitration agreement is null and void, inoperative, or incapable of being performed. Interestingly, what that provision does not tell us is what law do we apply to determine the validity, whether the agreement is null and void, inoperative, or incapable of being performed. So you must refer to the rules of private international law. In other words, the first question is not what substantive law of validity governs, it's what rules of private international law lead you to the substantive law that governs. So applicable law issues are important at each step here. So some observations on all of this, that when you read that Wismut problem and look at the jurisdictional question, Article 2.1 contains no rules on the law applicable to determine whether the parties have consented to arbitration. So that's outside of the New York Convention. It does require an agreement as a gatekeeping matter. You don't get into the convention unless you have an agreement. And Article 2.3 does not provide a rule for determining the applicable law on the question of substantive validity. So you have to know how to get to the applicable law for each of those questions. Just for a bit of comparison, the Hague Convention is very similar. Article 5 says the court or courts designated an exclusive choice of court agreement. Again, you don't get in there unless you have an agreement. Shall have jurisdiction unless the agreement is null and void. Looks like Article 2.1 of the New York Convention. But then the Hague Convention does something very different from the New York Convention. It tells us it has an autonomous rule of applicable law under the law of the state of the chosen court, which, if you think about it, is a circular problem, right? Because if you're trying to prove consent, and you look then, or prove validity, you look to the law of the state of the chosen court, but you have the consent to get there. Article 6 tells us that a court not chosen shall defer to the chosen court. But again, we see that autonomous rule of applicable law for questions of substantive validity. And Article 9 again provides the same autonomous rule at the recognition and enforcement stage. A very important distinction between New York Convention and the Hague Convention. Arbitration, you still have to go to rules of private international law to determine the applicable law because there is no autonomous rule of applicable law. Like the New York Convention, the Hague Convention has formal validity requirements. It's a more modern formal validity rule. In writing or any other means of communication, which renders information accessible so as to be usable for subsequent reference. So, on the question of consent, the applicable law is outside of the treaty. On the question of formal validity, each of the treaties has its rule that requires a certain form. On substantive validity, in the New York Convention, you get to the applicable law by rules outside the convention. In the Hague Convention, you have an autonomous choice of law rule. On scope, again, it's outside the convention. It's a matter of contract law, and the same thing for exclusivity, except the Hague Convention has a presumption of exclusivity. And I think we can say the New York Convention does as well. So you need to be aware of the governing law for each issue: consent, formal validity, substantive validity, scope, and exclusivity. you also need to be aware of the rule that results from that law, and then the words that produce the desired result. If you're drafting the choice of forum agreement, you have to use words that get you to the result that you want. So, a little bit of review here. The 5 basic elements of a choice of forum clause. And if we're dealing with this at the time of arbitration, these are, if you are the respondent and you want to avoid arbitration, you ask, how can I challenge the jurisdiction of the tribunal? And because jurisdiction is based upon only one basis, consent of the parties, these 5 elements are the only ways you can challenge the jurisdiction of the tribunal, by saying, we never agreed to arbitrate, or formal validity. We may have agreed, but the form is wrong and the form is required, and so it's ineffective. Or we may have agreed, except the law applicable, the law of the state that governs here, tells us that our agreement is not valid. It may not be valid because one of the parties lacked capacity. It may not be valid because one of the parties, the consent was given by someone who did not have the authority. That's an agency rule. It may not be substantively valid because the state law prohibits arbitration of certain types of questions. And this is that type of question. The next question is scope. And the drafter must have a clear indication of scope. And I've put here language that's kind of common language. And any and all disputes between the parties arising out of or related to this contract, or any claim resulting from their contractual or other relationships. That's broad scope. And most courts and arbitral tribunals will take the position that parties to an international commercial contract are presumed to want all of their questions addressed in one dispute resolution forum. And so that's a presumption of broad scope. Clear language regarding exclusivity. In an arbitration clause, that's usually not a problem. So here's the other part, though. Can you, in the contract, choose the law that governs all of these 5 questions? And quite often in a contract, you'll have a choice of substantive law clause that goes along with the choice of forum clause. You'll have an arbitration agreement, and then it says, this contract in all matters shall be governed by the law of state X. If arbitration is chosen, though, it's important to understand that there are multiple choice of law clauses, usually in the contract. The seat or the place of arbitration, there will usually be, the place of arbitration shall be Nepal. Okay. That is not a statement of the venue or the place where you'll find a conference room or a hotel room to have the arbitration. That is a choice of law clause. It chooses the arbitration law, the procedural law of that state to govern the arbitration procedure. But you also want to have that stated very clearly, and a clear choice of the substantive law applicable to the arbitration agreement. But then the next question is, if arbitration is chosen, should you clearly designate the substantive law for each possible challenge to jurisdiction? And can you do so? In today's world, I think every good arbitration law lawyer will tell you that you need not only to designate the seat that tells you what the procedural law is, not only to designate the substantive law that applies to the larger contract, but also to designate the substantive law that applies to the arbitration agreement. But as we've seen, yes.
I do have a question here, because
Okay,
on the last session that we had with Mr. Bone, we discussed about this Nepali case, which our Supreme Court decided. And this was the first case that the Nepalese Supreme Court decided with regards to enforcement of international arbitration awards. And in this case, a Nepali party and a Korean party came into a contract, and the contract did not have a very specific substantive law applicable to arbitration agreement.
No.
The contract only had the governing law of the contract as the Korean law. And the Korean parties decided that since parties have not decided on what the substantive law applicable to the arbitration clause would be, they simply decided it would be the Korean law. And thus they started the proceedings there. And when the Korean parties came to Nepal to enforce the award, the Nepalese Supreme Court decided that since the parties did not really agree on the substantive law of the arbitration agreement, does not necessarily mean that the contract's governing law would apply here. And that, along with various other reasons, they denied on enforcing the award. So how does it work, Professor?
Well, the answer is it doesn't work well in the current system. And here's why. Because, and this takes us back to Article 2, Paragraph 1 and Paragraph 3 of the New York Convention, particularly Paragraph 3, that does not tell us whose law governs the question of substantive validity. And it doesn't tell us whose law governs the arbitration agreement, and that includes questions of consent. And courts, and here's where one further breakdown is important, because what we see is it's most often courts that are telling us the answer to this question. And when we are in arbitration, we think the doctrine of separability and the doctrine of competence means it's always the arbitral tribunal that's going to decide this question, and that's wrong. Because even in arbitration, the authorities that most often get cited are courts for these questions. Now, and in some jurisdictions, there is either a presumption or a binding rule that the law chosen to govern the overriding contract is the law that governs the arbitration agreement. In other jurisdictions, and in fact, there is an amendment to the Arbitration Act in the United Kingdom, in England and Wales, currently in process in the House of Lords, that will change the rule to say that the law governing the arbitration agreement is the law of the seat of arbitration. That, I think, is wrong, because you choose the seat of arbitration for procedure, not for substantive law. But that's why you should be clear in the contract. You should not only choose the substantive law governing the contract, but expressly state that this is the law governing the contract, including the arbitration agreement. And then the choice is very clear. And in past vis moot problems, students have gotten into an analysis of the cases that led to the proposed amendment in the UK. The Inca case and Kebab G and the whole thing that goes through a 9-step analysis that's incredibly complex in order to determine what law governs. So the answer is, this is an area of complete lack of clarity, because different jurisdictions approach it with different either presumptions or binding rules. This is why the drafting is terribly important. And it's important to have an explicit choice of law. But the next question is, well, explicit choice of law for which of the 5 questions? Have you chosen the law for all 5 questions, or for just one or several of them? And so this always makes a great vis moot question, because of the lack of clarity and the lack of consistency in the case law. Does that, Prajwal, answer the question? Okay.
Yes, Professor. It has cleared some of the doubts. Yeah, thank you.
Okay, and others, please do jump in. I know we're at a 1-hour time mark, right? We're shooting for being done in 1 hour. Okay.
Yes, Professor.
And I'm getting there. So, okay. But And here's where, and this is important in vis moot problems and the analysis in a vis moot problem. And that is the extent to which we sometimes, when you divide up the responsibility on the team, the procedural people think, ah, wonderful, I don't have to understand the CISG. Wrong. Everybody has to understand the CISG in the vis moot problem, because the CISG has a role in jurisdictional challenges. Because on the 5 basic challenges, if we look at the question of consent existence, that most likely will be governed by the CISG, because the parties will be in states that are contracting states to the CISG. Now, formal validity is governed by the New York Convention and the Lex Arbitri. So that's different. Substantive validity, well, capacity, arbitrability, validity, those are outside the CISG. So you have to be able to use the rules of private international law to determine what law does govern substantive validity. And in the vis moot, that often leads you to the unidroit principles, which normally would never apply as law, but are often written in as the statutory law of the hypothetical states involved. Scope and exclusivity, those are matters of contract interpretation. That's governed by the CISG. So the CISG is incredibly important to questions of jurisdiction of the arbitral tribunal. And let's look at this. If we look at consent, Article 1A says the convention applies to contracts of sale of goods between parties whose place of business are in different states when the states are contracting states. This is a rule of applicable law in the sales convention. Now, here's the question. Is an arbitration agreement with the doctrine of separability in an international sales contract part of the sales contract or separate from that? And here's where it's important to understand the doctrine of separability. The doctrine of separability is a validity doctrine, not a consent doctrine. It doesn't apply to every question. And so when we're talking about, and most courts and arbitrators have said, look, when we're talking about whether there is the existence of an arbitration agreement, that's not a validity question. The doctrine of separability doesn't apply. We put that all together and the entire contract is looked at together. And so the CISG Article 1.1a is important and does apply. When we go to the 4th and 5th questions I've laid out, scope and exclusivity, that's where you have to understand the CISG Articles 8 and 9. Did the parties intend for this arbitration agreement to cover these issues? And here's where you can bring in other evidence, statements made by the parties or their conduct, help you are to be interpreted according to that party's intent, the substantive intent rule, which hardly ever applies because each party will say that it's different. So we look to our paragraph 2, the understanding that a reasonable person of the same kind would have had in the same circumstances. But then we are aided by Article 8.3 that takes us to practices the parties have agreed to, and usages and subsequent conduct, and further to Article 9, usage to which they have agreed, practices they have established, what we would call, and then paragraph 2, party usage, or what we call usage of trade in the particular industry. And so it's important, you have to use the CISG to interpret the contract. You have to use the CISG rules of contract formation to determine if the parties consented to an arbitration agreement. And a caveat here, quite often you'll hear people argue Article 7. But Article 7 does not apply to contract interpretation. It's interpretation of the sales convention. Articles 8 and 9 are the rules on contract interpretation. But Article 7 may help lead to the law applicable to issues that relate to jurisdiction of an arbitral tribunal. And here, now, important to note, though, that we see this good faith, and Article 7 has an obligation of good faith, not in the contract performance, but in the interpretation of the convention. There is no explicit rule of good faith in contract performance, although many commentators, particularly from civil law systems, have said that there is such a rule as a general principle. But questions concerning matters governed by the convention, not expressly settled in it, number one. If it's settled in it, you're done. If it's not settled in it and covered by a general principle, you apply that. And if you can't get to either of those, you apply the law applicable by the virtue of the rules of private international law, which means that even if you go back to the Sales Convention, you still have to understand the rules of private international law. And that's so. Have we gotten there? My hope is, and I'm going to I don't know if I can, yeah, I'll stop share here. We're just about in an hour.
Yep.
And my hope is that this has provided a framework that makes you ready to think about challenges to jurisdiction of an arbitral tribunal. When you read a vis moot problem, or quite often, if you represent a client that doesn't want to go to arbitration, the other party has already filed for arbitration, how can you challenge that? And it's best if you have a framework that allows you to work through step by step how you can do that. And I hope this has been helpful for that purpose.
If anyone has questions for Professor Brand, just unmute yourself and present the questions.
Can I have a question? For example, I have a question about in contract. For example, parties want to give definition about fundamental breach, and they say we consider these two cases as a fundamental breach, and only in fundamental breach one of the parties can avoid the contract. But CISG says that gives definition to fundamental breach, and I think this definition is more broad than some contracts. So which one we need to prefer? The broader definition according which is the CISG governing this contract, and in this case we need to prefer the narrow definition according to the contract, or we need to prefer CISG.
Yeah, and that was a question this past year, because there was a provision, either this past year or the year before, I get all the problems mixed up. There was a provision in the contract that certain matters constitute fundamental breach. Now, fundamental breach is a concept that's included in the CISG. It's not in the law of the contract law of every state, even states that are parties to the CISG. What's important there is to understand first what is a fundamental breach, and that's a breach that substantially deprives the party of what it was entitled to under the contract. But the first step is to prove breach, and then you have certain rights, but you have additional rights if you prove fundamental breach, a higher level of breach. And this goes to what I've been discussing, which is the contract drafting side of the question here. If the transaction is going to be governed by the CISG has a definition of fundamental breach. But the parties can, and in the vis moot problem, have written in that certain matters are clearly going to be considered fundamental breach, so the court or the arbitral tribunal doesn't have to decide, well, is this a fundamental breach under the test in the convention? Okay. Now, that leads you to a further question under Article 6 of the CISG, because the parties can replace or derogate from any provision of the CISG. If the parties in their contract have said X constitutes a fundamental breach, have they totally derogated from the other fundamental breach rules of the convention and said only this constitutes a fundamental breach, or have they simply added to it or made something more explicit? And that's a question that you still have to address. And that's a question that you want to be clear on if you're drafting the contract. Okay? But it's a matter that if the contract drafter hasn't been clear on, then the party interpreting the contract has some difficulty there. Does that answer your question? I mean, I take the question to mean, what if the parties have said something about fundamental breach in their contract? And that raises the Article 6 question, but it also it raises the question of, is this just a clarifying statement that you don't have to go into detail under the convention to determine whether it's a fundamental breach, because we've agreed that it is? And that's the basic starting point. Does that answer the question?
Thank you so much.
No, okay.
Anyone else?
I have a question.
Unmute yourself, please.
I'm not getting sound here.
No, you're not.
Okay, maybe I can ask you something while he fixes his audio.
Yeah,
Sure.
please do.
So when it comes to these 5 bullet points that you said for challenging jurisdiction, you said that consent can also be the matter of the CISG, but when it comes to validity, it is not a matter of the CISG at all, right?
Yes. And that it depends on the type of validity. Formal validity is going to be governed by the arbitration law. The New York Convention has a rule on formal validity. The UNCITRAL model law has a rule on formal validity. Substantive validity depends on what is the substantively applicable law. And Article 4 of the CISG specifically excludes questions of validity from the scope of the CISG.
Oh, yes. Okay, thank you. Thank you so much.
Does anyone else have questions for Lakpa fixes his microphone? While he fixes his microphone, Professor, I have a question.
Okay.
Yeah, I suppose it's a very simple question, but I do have confusion to this. So how does a jurisdictional challenge in international arbitration differ to a jurisdictional challenge in a domestic arbitration? Are there differences to it?
Well, it's governed by different law. In a domestic arbitration, the New York Convention will not apply. And in the United States, for example, in our Federal Arbitration Act, we have Chapter 1 that deals with arbitration and Chapter 2, which implements the New York Convention. And the rules are a bit different than the Chapter 1 rules for domestic arbitration. We have an odd common law ground for non-recognition in domestic arbitration that doesn't exist in international arbitration. So you can have differences in those. And it is important, and this has arisen in countries that that are new to adopting or amending or drafting new arbitration laws. And one of the reasons I think it's important to draft laws that are as close to the UNCITRAL model law as possible, but to make it clear whether your rules apply to all arbitrations or if you have statutory rules that are different for domestic and international arbitrations. And that's a matter of reading the statute of the applicable country law.
And Professor, another follow-up question. We see this a lot in Nepal, especially with regards to public policy. When the parties come to enforce arbitration in Nepal, the opposing party would always make an argument with regards to public policy. And most of the times they win their argument with public policy. Now, how does public policy affect the jurisdiction challenge in arbitration?
Well, in the United States, parties always raise public policy as a ground for non-recognition as well, but they almost always lose. And so that's and the intent, both in the New York Convention and the Hague Convention, when we drafted that, is public policy. I'll tell you what the main purpose of the public policy ground for non-recognition is. It is in order to get states to ratify the convention. Because without that, states say, look, we just don't want a blanket obligation to enforce every arbitral award that comes along. We need an out. And the public policy is the ground of non-recognition that makes governments comfortable in ratifying the convention. But on a global basis, it's generally understood that that is a narrow ground. A simple difference in policy is not public policy for purposes of the ground for non-recognition. It has to be a fundamental difference in the system. And that's what it should be. That's not always the way it's applied in every country.
Professor, we have a question in the chat. I'll read it for you. What is the significance of the seat of arbitration in determining jurisdictional authority? What recourse do the parties have if they disagree with the tribunal's decision on the jurisdictional challenge? And can a seat influence the outcome of the award indirectly?
Good questions. The seat of arbitration is incredibly important. And because it is a choice of law clause. When you choose the seat of arbitration, you have chosen the arbitration statute, the arbitration procedure of that state. You've also chosen the courts of that state to govern the arbitration procedure. You've also chosen the courts of that state to determine any challenge to the award to try to annul the award or set aside the award, because you can only do that at the seat. And so that's one of the most important provisions of an arbitration agreement. If you disagree with the tribunal's decision, and this is an important drafting issue, and this is where once the Hague Choice of Court Convention becomes more widely adopted, what has always been said is an advantage to arbitration is that you get the award, it's binding, you don't have to go through multiple appeals, you're done. And that's been seen as an advantage. It's not an advantage if you get a bad decision. It's a disadvantage. And so if what you want is the opportunity to overturn a bad decision, you should choose going to court, not arbitration, because you've given that away in arbitration, and it's important to understand that. Now, what you can do is try to annul the award or have it set aside, again, in the state of the seat, in the courts of the state of the seat of arbitration, or when the award is taken for recognition and enforcement, you can challenge recognition, but you have much more limited grounds than you would have to challenge a bad decision on appeal in the courts. And so that's a decision that's made at the contract drafting stage, that you want efficiency over equity, in a sense. You want a fast result that doesn't allow appeals and ends the process, but it gives you the risk that you'll end the process with a bad decision. Can a seat influence the outcome of the award indirectly? Yes and no. It really should not. But the choice of seat then ties you to the statutory arbitration procedure law of that state. It also means that the courts of that state have supervisory authority. If you choose, some people talk about choosing arbitration to get out of the courts. Well, you can never get out of the courts, because the New York Convention and every arbitration statute provides a role of supervision for the courts. And so, yes, the seat can influence the outcome, and it depends upon how heavy that role of supervision is under the statutory law, the lex arbitri, of the state of the seat of arbitration.
Yeah, thank you very much, Professor. Does anyone else have any further questions? If not, I think we'll be ending our session here today.
Good afternoon, Professor. It's very nice to see you again. I would like to ask a basic question in connection to the last year case as well. Well, my question would be that the validity of arbitration agreement from the view of arbitral institutions, where none of the parties challenges the validity of arbitration agreement. However, the arbitration agreement does not comply with the institutional rules itself. And then the institution does not want to govern the arbitration. Does it affect the validity of the arbitration agreement, since the parties explicitly agreed in the arbitration agreement with the name of the rules and with the institution?
Yeah, well, it certainly affects the challenges that can be brought. And this is a gray area to a certain extent, because there's a hierarchy of the set of rules and a reverse hierarchy in applying them. I mean, the New York Convention rules will trump anything else because they're treaty law. But then the lex arbitri, the statute of the seat, will limits you on what you can do. But then beyond that, you choose the arbitration institution and its rules. And of course, the New York Convention has fewer rules than does the statute, and the statute has fewer rules than does the set of arbitration rules of the institution. But you reverse that process, because to the extent that the rules in the New York Convention and the statute are default rules, they can be changed by the arbitration rules that are chosen by choosing the institution. But then ultimately the contract can change all of that to the extent that the rules are only default rules. So the way I see your question is, are the attempts to change the rules of the arbitration institution an attempt to change what the institution considers to be a default rule or a mandatory rule of the institution? And that's the way I would analyze that. And some arbitral institutions, and at this point, that normally is determined, I think, when a party files for arbitration, the arbitral institution should look at the contract and say, have they changed? Do we want to administer this arbitration given what they've done in the contract? If they have changed our rules. Once the institution takes it on, I think it's a little hard to do that. But that's where the institution, and that's where the oversight and administrative authority of the institution becomes important. And the institution should, at that initial stage, make that determination. If they haven't, then you have that problem of whether that institutional rule is a mandatory rule or one that the parties can change. Does that make sense?
Yeah. Thank you so much,
Good
Professor.
question. Yeah.
So Professor, with regards to the previous question, where do we draw the line between the party autonomy and you agreeing to the institution rules? Where do you draw the lines?
Right here. No. Well, that's a question of, and this is a fundamental problem of private international law, and that's determining which rules of private, which substantive rules are mandatory and which are simply default rules that the parties can contract around and contract out of. And so, and this is where legislative drafting is important, because if the legislature wants a rule to be a mandatory rule that parties cannot draft out of, they should make that clear. And if they don't, then you have it's not a contract interpretation problem, it's a legislative interpretation, it's a statutory interpretation problem that you have. And so you kind of raise, you have the same questions, you raise it to a different level in that process. Should there be complete party autonomy? Most states have said no. This is a good example where a comparison between the U.S. and the EU comes in. The U.S. the U.S. Supreme Court has interpreted the ratification of the New York Convention and the Federal Arbitration Act to adopt a very strong policy in favor of arbitration. And so even consumer cases go to arbitration, and even click on agreements. This is why when you sign up for Facebook or Amazon or eBay or anything else, go read their choice of forum clause before you do that, because when you click, you've agreed to that. Now in the EU, consumers are protected from that. I don't like the word protected because it often harms the consumer, I think. But consumers cannot do that because there is a rule of substantive validity that's a mandatory rule that says consumer contracts, you cannot have a binding choice of court or arbitration agreement, pre-dispute binding agreement in a contract. Same thing for insurance contracts, same thing for employment contracts. And so it is a matter of legislative drafting, and there's a need for clarity in that.
Are there any further questions?
No.
If not, I think we'll be ending the session here today. Thank you for those who've attended the session here, and especially the very good questions the participants have asked to Professor Ram. And thank you, Professor Brand, for agreeing to have this session here today. And we hope to have another session with you very soon. And we'll be providing the recording of the lecture series to all of you to our YouTube channel. And we'll be emailing you all of this. And if you have any suggestions as to what our next session should be about, please do write to us. Yeah.
Thank you, Prajwal. Thank you all for joining. And I look forward to seeing you somewhere again along the line. Maybe that'll be at the University of Pittsburgh in our LLM program. I'd like to see you there. So have a great day or great evening. Take care.